Hi, I'm Dave Zumpano, and if you're an estate planning attorney or deal with the estate planning industry in any way, I'm here to tell you it's changed dramatically. Has your practice changed to keep up with it? Change, you say? Why? Well, first thing you have to do is ask, what is it that clients really want? What do they write checks for in this environment? To answer that question, you have to examine what this environment is. So let me take you through a short track of over just the last 10 years. So let's take a leisurely walk back to the year 2001. What happened? Well, I know 9/11 happened, and for the first time on American soil, we lost loved ones that we sent to work due to an act of war here on our domestic soil. While it seems like an act that we've memorialized in statutes and other events, it really did something much greater. It changed this. It changed the way people think. In addition to the 9/11 impact, what followed was in 2001 we had the burst of the tech bubble. If you think back to prior to that, in the 90s, you could throw a dart against the wall and pick the next best stock, growing double digits. People were buying homes and selling them before they even closed on them at a profit. And what happened? Well, just since 2001, we have seen the collapse of the tech market, we have seen the collapse of the stock market, we have seen the collapse of the banking industry, the financing industry, the auto industry, and possibly even government itself, all in the last 10 years. Governments, we wished and complained about $300 billion deficits, and now just a few years later, we are experiencing annual $1.5 trillion deficits and a national debt now blowing through the $14 trillion mark. What does this mean for members of the people we serve? It means all of this has changed. Let's look at a few other things. What's happened with the tax law? The tax law in 2001 was changed that has basically made estate tax planning no longer relevant for virtually all Americans. Now, for those of you that do that, I understand you're getting sensitive and squirming. Here's the reality check. It's gone. 99.99% of Americans do not need estate tax planning. 1 in 1,000 Americans have a taxable estate. This is significant. When you combine that with all the events that the American people have experienced in just the last 10 years, combined with the restrictions that the traditional tax planning plays, you will identify a whole new market begging and trampling lawyers for some simple things. What is it that clients want? 3 things. Number 1, these boomers, they've worked hard for their money. Well, they want to provide for their kids. They want to make sure it's there for them first. But they want to always make sure they maintain control. They don't ever want to lose that control. Number 2, they want flexibility. They want to keep it simple. They want to be able to change it. But number 3, they want protection. Interesting, the last 19 years I've been doing this, for years, I've asked what they wanted protection from. The number 1 answer was always nursing home. No longer. Today, the number 1 answer clients give me is government. The thought of government and their overbearingness on people, whether you agree with it or not, is affecting the way people think. They want control, they want flexibility, and they want protection. Now, as an attorney, this is an interesting dichotomy, because we know from doing planning that we traditionally have to take away control or access if we want protection. But that's where everything has changed. That's true in the old days, just a few years ago. Because in the old days, protection from taxes meant creating non-grantor trusts for our clients. The Irrevocable Life Insurance Trust, GRATs, GRUTs, Q-Ports, ILETs, Q-Dots, all these different trusts we create, non-grantor intentional, to reduce or minimize estate taxes, are no longer relevant. Let me say it again, 99.9% of Americans. Now, for those of you that want to serve the point 1, I make no disdain about that. I wish you continued success. But for me, who chooses to serve the 99.99%, what is it and how is it that we get them this? Well, it's very simple. And they like simple. The Irrevocable Pure Grantor Trust has changed everything. Now, while you think it's new, it's been around for a very, very long time because it's based in common law. not based in statute. So what is an Irrevocable Pure Grantor Trust, or IPUG trust? Well, it's an irrevocable trust that has certain features that gets a certain result for clients. What results does it get for clients? Well, it allows clients to remain in control. It allows clients to maintain flexibility and the ability to change many, if not all, aspects of the trust. And thirdly, it protects their assets from lawsuits, the government, and yes, even nursing homes, and it's Medicaid compliant. The features are that it's a pure grantor trust. What does that mean? Well, I don't want to get into all of that here, but that's a tax rule to identify how the trust is taxed. Essentially, an IPUG trust is taxed like a revocable living trust, totally taxed to the grantor as if the trust does not exist, while providing the grantor the protection he seeks, the flexibility to change it, and the ability to control it. How do you find out about these? It's simple. Recently, Syracuse Law Review released an article called Irrevocable Pure Grantor Trust, the estate planning landscape has changed. In this article, it will be a complete, thorough analysis, first and foremost, of the tax treatment of trusts and how irrevocable pure grantor trusts have specific tax treatment, unique and different than what most of us are used to. Second, it will examine the features of an irrevocable pure grantor trust. Most notably is the feature of allowing the grantor to be trustee, sole trustee, or co-trustee of his self-settled irrevocable trust. A second important feature is the retention of powers of appointment to the grantor during life and after death that ensures the ability of the grantor to be flexible and be able to change his planning as he chooses. And third, it allows the grantor to benefit in one way, shape, or form from the trust. The caveat is this is not a kumbaya trust. This is a trust that the grantor must give up one thing. And the one thing the grantor must give up is that which he wishes to protect. So for example, if a grantor wishes to protect their principal, then obviously in the IPUG trust, they will be giving up their right to principal. But they do not have to give up their right to change the trust, change the timing, manner, and method of distribution, to give up control of the trust, or many other features that today's grantors are looking for. Now, this is inconsistent with what we've always been trained and taught, but it really isn't. It's just we haven't been trained and taught it because for so long we've been letting the tax rules dominate our estate and trust planning. So, what the Law Review article does is after it distinguishes the tax elements and the features, it will then go through and identify the particular uses in today's world, in this post-2001 to 2011 world, and show you how these trusts really apply in everyday America for everyday Americans, how it applies to business owners, professionals, and that gigantic market of people who want to protect their assets from loss to a nursing home or even lawsuits. In 2007 alone, there was 103 million legal proceedings in the United States initiated. 103 million in just 2007 alone. That may be insignificant to you or I as attorneys, but to the client market we serve, it's very primary on their minds. The article concludes after discussing the particular uses of the trust and the three different types of trusts, IPUG trusts. It then finalizes by distinguishing the IPUG trust from domestic asset protection trusts, distinguishes the bankruptcy issues, fraudulent conveyance conversations, and all the other tangential areas that come in to irrevocable trust planning. It helps distinguish all these things and show how the irrevocable pure grantor trust is founded fundamentally in the common law, is 100% compliant with the Uniform Trust Code, the Restatement Second of Trust, the Restatement Third of Trust, and all the relevance of those legal treatises and support and background. IPUG trusts work consistent with all the rules under there. This is not new, It's just a new application of what we've always been able to do, but have never done because of the tax rules clouding our eyesight. And so I encourage you to request a copy of the Syracuse Law Review article, The Estate Planning Landscape Has Changed, Irrevocable Pure Grantor Trusts, discussing them. And you can get that one of two ways. You can go to our website, mpssuccess.com, MPS Success, so that's two S's in the middle, mpssuccess.com. There's a button for the free copy of the article. Secondly, you can go to the Syracuse Law Review for reference. It's Syracuse Law Review, volume number 61, number 1, 2010. I look forward to helping you help the people we serve, because it's all different now, and you need to be prepared to help them. If you won't, who will?